Hi everyone, welcome to part 2 of our week 2 lectures. In this video, we'll look at the duties of the Bailor and the Bailee, as well as special types of Bailee. At common law, Bailors have two key responsibilities. Please note that a bailment agreement might add more, but we'll just focus on these two as the most fundamental. The first duty is not to interfere with the Bailee's possession. The main rationale behind this requirement is to provide certainty. As we'll see later, there are clear guidelines about when a Bailee will or will not be responsible for damage to the goods, and the Bailor's interference with the Bailee's possession might cloud these principles about liability if loss and damage occurs. The second responsibility is to inform the Bailee of any dangers associated with the goods of which the Bailor is aware. A Bailee who accepts the goods after being informed of the danger will have no recourse against the Bailor for damages arising from that danger. Meanwhile, Bailees have four key duties. Again, more might be added through a bailment agreement. The four duties are pretty straightforward. Bailees must take reasonable care of the goods, retain possession or deliver the goods as the Bailor directs, not use or misuse the goods other than per the Bailor's instructions, and to redeliver or return the goods as the Bailor directs. If a good is damaged or lost while it is the subject of a bailment, the Bailee might be liable to the Bailor. All Bailees are responsible for their own negligence, but there is a different liability beyond that for gratuitous versus for payment Bailees. A Bailee of a gratuitous bailment is only liable for their own negligence, while a Bailee who receives payment is also responsible for their agents' and employees' negligence. This means that the distinction we raised in the previous video becomes very important if something goes wrong. A Bailee's liability can be excluded by contract, such as a bailment agreement, but services supplied to a consumer in trade or commerce cannot be excluded under the Australian consumer law. We'll be taking a closer look at the Australian consumer law in week 8 when we look at consumer protection, but this is a little exception that's worth keeping in mind for now. Finally, let's look at two special classes of Bailee, common carriers and innkeepers. These classes have long historical roots which inform their rights and duties. The first, common carriers, are Bailees who carry on a business as a carrier of goods. Their job is to accept goods as a Bailee and deliver them somewhere else per the Bailor's instructions. The main distinction between common and private carriers is that common carriers do not reserve the right to accept or reject the transport of goods, with limited exceptions. Here it might be helpful to think about the conduct of Australia Post and many courier companies. These companies agree to transport goods without really stopping and asking you what the goods are. In other words, the agreement to transport is not reviewed on a case-by-case basis. On the other hand, private carriers will consider the terms of each individual transport agreement and accept or reject each one individually. The main implication for common carriers is that they are insurers for the safe carriage of goods and are therefore liable for damage or loss of any kind, whether they're negligent or not, notwithstanding a force majeure. Innkeepers are the second type of special Bailee. Innkeepers offer accommodation to travellers, and here we distinguish between guests and lodgers. The difference between guests and lodgers is that a lodger is someone who has made prior arrangements for their stay for a definite period of time, while a guest is more impromptu, having arrived at the inn or other accommodation, having made no prior arrangements for their stay. Because of the certainty around their visit, lodgers are simply treated as any other bailor with regard to goods entrusted to the innkeeper's care. However, innkeepers are strictly liable for the loss of guests' goods regardless of negligence. If the goods are damaged, the innkeeper is only liable if the damage arises from their negligence. Liability is limited by statute to $250 per room or $50,000 for goods in safe custody. But here we really see an interesting historical quirk where a road-weary guest having made an unexpected stoppage at the inn is protected more comprehensively than someone who has had the time to pre-organise their stay and also to make better provisions for their goods. In modern times, internet booking and other technologies make guests a rare class of traveller. However, this special class remains important for us as students of the law, as it provides a good example of how bailment is driven by the relationship between the Bailee and the Bailor, taking into account a wide array of facts and circumstances to offer the most security and certainty to both parties. On that note, we'll conclude this week's lectures. See you next week.